Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court and then move on to High Courts and other subordinate courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. Let's begin for the day. In an interesting development, the Supreme Court of India today refused to entertain a petition seeking directions to the central government to declare cow as a national animal. A bench of Justices S.K. Kaul and Abhay S. Oka allowed the petitioners to withdraw the petition after a request to this effect was made at the end of the hearing today. When the matter came up for hearing today, the counsel appearing for the petitioner submitted that protection of cows is very important for the Indian government. However, this argument invited a negative response from the bench as they remarked during the hearing, and I quote here, "Is it the job of the court to declare an animal as a national animal? Why do you file such petitions in which we are compelled to impose costs?" We have made a detailed video on today's hearing, the link to which has been given in the description box below. The Supreme Court today agreed to list tomorrow the petition filed by Delhi Government Minister Satyendra Jain challenging the Delhi High Court order which upheld the transfer of his bail plea to another court. Senior Advocate Kapil Sibal mentioned the matter before Chief Justice of India UU Lalit for urgent listing tomorrow. The CJI agreed to list the matter tomorrow as the first item. On September 22nd, the Principal District and Sessions Judge of Patiala House, Delhi, had allowed the application made by the Enforcement Directorate to transfer the plea of Satyendra Jain from Special Judge Gitanjali Goel to Special Judge Vikas Dhul. The ED had raised apprehensions of bias against the judge on the ground that the ED's objections to shifting Jain to hospital were not considered. Amidst the speculations about the Supreme Court Collegium meeting held on September 30th, a joint statement has been released by the Collegium members stating that the said meeting has been discharged in view of the Union Law Minister's letter to Chief Justice of India UU Lalit on October 7th asking him to name his successor. As per the statement, two members of the Collegium, Justices D.Y. Chandrachud and Abdul Nazir, raised an objection to the letter circulated by CJI Lalit seeking their views regarding proposals for elevation to the Supreme Court. The two judges objected to this process of selection and appointing judges by circulation. For more information regarding this controversy, you can refer to a detailed video, the link to which has been given in the description box below. Please do check it out. The statement released by the Supreme Court Collegium today has revealed an interesting fact that the Collegium has introduced a procedure for scrutinizing the judgments authored by the High Court judges who are under consideration for elevation to the Supreme Court of India. The Collegium has also introduced a procedure to assess the relative merit of candidates on an objective criteria. However, the exact parameters is not known. The procedure was introduced for the first time in the Collegium meeting held on September 26th under the leadership of the Chief Justice of India, UU Lalit. In a contempt plea alleging blatant and disobedience by the DGP of Uttarakhand Police and DGP of Delhi Police to take action with respect to hate speeches made by prominent persons in Dharma Sansad in Uttarakhand at an event organized by the Hindu Yuva Vahini in Delhi, the Supreme Court today directed the Uttarakhand government as well as the government of NCT of Delhi to file affidavits explaining the factual position and also the action taken by them. A bench comprising Justices D.Y. Chandrachud and Hima Kohli said that at this stage it would not issue notice in the contempt petition which was filed by Tushar Gandhi. The Supreme Court today agreed to list tomorrow the petition filed by the Enforcement Directorate challenging the Bombay High Court's order granting bail to NCP leader and former Maharashtra Home Minister Anil Deshmukh in a PMLA case. Solicitor General of India Tushar Mehta mentioned the ED's petition before the Chief Justice of India for urgent listing. The bench led by the CJI directed that the matter be listed before a bench led by Justice D.Y. Chandrachud tomorrow, considering the fact that Justice Chandrachud's bench had earlier dealt with Deshmukh's application. Although the High Court passed the order granting bail to Deshmukh on October 4th, it kept the order in abeyance till October 12th at the request of the ED. The Supreme Court today posted to October 20th the petition filed by the Enforcement Directorate seeking to transfer the trial in the gold smuggling case from Kerala. A bench comprising Chief Justice of India UU Lalit and Justice S. Ravinder Bhatt allowed the application filed by the state of Kerala seeking impleadment in the ED's petition and issued notice to the state. The state has been allowed to file its reply by this Friday. The bench said that it will dispose of the matter on the next hearing date. Former Maharashtra Chief Minister Uddhav Thackeray has moved the Delhi High Court against the Election Commission of India's decision to freeze the Shiva Sena's bow and arrow party symbol. In the alternative, Thackeray has sought a direction that the Election Commission of India be asked to consider and allot the symbol proposed by him without restricting the choice of symbol from the list of free symbols notified under the symbols order. The ECI on October 8th had directed both Uddhav Thackeray and Eknath Shinde groups to not use the name Shiva Sena or the symbol bow and arrow till the claims of rival factions for the official recognition is finally decided. The Karnataka High Court has said that the government should come up with some regulatory measures to check the growth of therapists who offer their services online, including via social media. A single judge bench of Justice M. Nagar Prasanna observed, and I quote here, "It is in public domain that there are huge mushrooming of so-called therapies and therapists on social media, as the case would be, wherein therapists pose themselves to be in the field of any therapy. It is also in public domain that they are all pseudo-therapists who are Instagram influencers." The court also added that there are many people on social media who claim to be therapists but are not bound by any ethics or regulated by any norms. The National Investigation Agency, that is the NIA, today informed the Delhi High Court that copy of the FIR and the grounds of arrest in the case registered against alleged members of Popular Front of India has been provided to Muhammad Yusuf, an accused arrested recently in one of the raids conducted by the agency. Special Public Prosecutor appearing for the NIA, however, objected to the prayer seeking a copy of remand application on the ground that the appropriate forum for seeking such a relief is the trial court and not the High Court. The SPP also informed the bench of Justice Anup Kumar Mendirata that the remand application prepared by the agency is akin to the case diary maintained by the investigating officer, adding that the accused does not have an inherent right for supply of the same. The central government today informed the Delhi High Court that the matter relating to the issuance of a no objection certificate to Pakistani Hindu migrants who are allegedly residing in the city's Adarsh Nagar area without proper electricity connection is being looked into at the highest level. A division bench of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad granted a period of 3 weeks to the centre for filing its response in a public interest litigation petition seeking directions for including Aadhaar card and long-term visa as a sufficient proof in respect to occupancy of the premises to enable them to apply for electricity connection. While listing the matter for further hearing on November 10th, the court said, and I quote here, "At least you should have given them a Diwali gift." Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching Courts Today on LiveLaw for more such updates. See you tomorrow.